My lord, I pray for listing a motion matter.
What matter?
My lord, item number 12. Conducting advocate of R3 cannot be present today due to health problem.
Item number?
12.
Who is conducting?
S. Dasgupta.
Okay. You have informed the other side.
I am junior to him.
No, you have informed the petitioner side.
No, R3. Yes. Yes.
Petitioner is there.
Yeah.
Your name?
TK Bora.
Okay. Mr.
H. Day.
H. Day. Learned Counsel representing Mr. S. Dasgupta, Learned Counsel for the private respondent or what? For the respondent number 3. Has submitted that Mr. Dasgupta, yes, what happened to Dasgupta?
Health is not.
Okay, Mr. Dasgupta is indisposed. So it is submitted that the case be listed. It is paid that case be listed after 2 weeks. Mr. TK Bora, Learned Counsel for the petitioner, is present and has no objection to the said prayer. So in view of the grounds cited for adjournment, the prayer is on behalf of the respondent number 3. The prayer is allowed. Leaves the case after 2 weeks on the previous office. Tomorrow.
Because the oblige, my lord.
May I please, your lordship, with the consent of the other party, I would like to mention item number 11, your lordship. Lordship, Mr. R. Pujari appears for this matter. Today, he has some personal difficulty, your lordship, so the matter may be adjourned for the day.
Who is for the petitioner?
I am for the on behalf of PD9.
Mr. H.
Lordship.
You are for?
Of petitioner Lordship on behalf of PD9.
Okay. MS RM Borua, Learned Counsel representing Mr. R. Borfuzai, Learned Standing Counsel. Finance.
Yes, your lordship.
Finance Department has submitted that Mr. Borfuzai has some personal difficulty to conduct the case today and has paid for listing of the case after 2 weeks. Mr. A. Chetri, Learned Counsel representing Mr. PD Nar, Learned Counsel for the petitioner is present and has no objection to said prayer. In view of the prayer made on behalf of the Standing Counsel and Standing Counsel Finance Department is allowed. It is submitted. You have informed the other sides.
Yes, Lordship. I am for the
Yes,
High Court,
sir.
Lordship.
Submitted by MS Borua. That consent has been taken from the Learned Counsel for the other respondents to make the prayer. The prayer is allowed. Is the case of the petition.
Obliged.
Made to the Lordship. My lord, I am praying for your lordship indulgence, my lord, to allow posting of a very urgent matter unlisted today, my lord. My lord, this matter is basically regarding, my lord, a tender process in which, my lord, on 5th of September, day before yesterday, they rejected my technical bid without assigning any reasons which is mandated under the terms that they should give. And yesterday, they fixed the matter for finalization today, my lord. Today is the last day at 3 p.m. They will open.
What kind of tender process?
This is regarding, my lord, a supply of my lord, an item called Napier slips, which is a grass, my lord, issued by the Agriculture Department, which is used for one of it is kind of fodder, which is used for the cattle. Now, they in the NIT has given only 3 days timing. If your lordship sees the NIT, my lord, that only 3 days timing has been given to complete the tender process after the work order is issued. My lord, my apprehension is that if today at, my lord, 3 PM, they open the price bid, tomorrow they will give the final order, and in 3 days, they will complete the process, my lord. So that is the difficulty. I'm praying, my lord, kindly accommodate for today, my lord, at 2 if possible, my lord. Only 1 day time they gave me, and that too without giving any reason, they cancel my bid, my lord.
If your submission is wrong, heavy
No.
cost will be imposed.
My lord, I'll submit before your lordship that price bid is fixed to be
I am
open.
making it clear.
Yes, my lord, of course, my lord. My lord, there's nothing to conceal, my lord. There's nothing to conceal, my lord. It is apparent on the paper, my
If
lord.
it turns out to be a wrong one,
My
then heavy cost will be
My
imposed.
lord, the petitioner herein, my lord, is praying for a little accommodation that the price bid may be kept in abeyance, my lord. Not tomorrow, if your lordship is satisfied.
We'll see with it. That is a defined issue altogether.
Yes, ma'am.
Okay.
May I submit? I'm deeply obliged, my lord.
But have you filed it or not?
Yes, my lord. Today morning only I have filed it, my lord.
Yes.
I'm deeply obliged, my lord.
Lordship, I beg to mention item number 9 of today's list, my lord. My lord, some health problem, my lord.
Well, this is almost 2013. This is almost hard.
Yes, my lord. Little accommodation, my lord. Next week, my lord.
No, we'll see to that.
Lordship,
If it does not reach, it is okay. Otherwise, I have heard you.
yes, my lord. My lord, next week.
Only thing is that the private respondent, he was not there.
Actually, my lord, one more thing. The G20 summit is going on, so the instructions are not coming, my lord.
No more instructions required.
My
Only
lord, that-
thing is that private respondent was not represented on the previous date. He did not.
Yes, my lord.
We'll see to that.
May I please, Lordship? Lordship, pair for listing a WBC, Lordship, for admission, Lordship. Lordship, urgency is that,
What is the subject matter?
Lordship, the petitioner is a stone caster unit, Lordship.
What of me? Okay, next week.
Deeply obliged, Lordship.
For admission item number 1.
Before my learned senior counsel starts, my lord, on the last occasion on 24th of August, this court has directed me to produce the records. Now, even though the advertised location is of Jorhat, my lord, but the administrative office is Tinsukia Divisional Office. The records are not here, my lord. I pray for a short accommodation of it.
Why? Because I would have no objection, but only thing is that my learned friend from the next time would inform at least in 1 day in advance so that I.
My lord, I'm extremely sorry. I'm extremely sorry.
Well, your lordship, then may I pray for that?
Okay.
I have a matter.
There was an order for production of records.
Yes, but he has said some difficulty is there. Your lordship will accommodate him. Well, the only thing is that may I pray for a date on Tuesday on 22nd of September,
So see, we'll try to
26.
accommodate.
26th.
No. Mr. B.D. Korn, our senior counsel, assisted by Mr. Jay Singh, learned counsel for the petitioner is present. Mr. P. Bharadwaj, learned counsel appearing on behalf of the IOC, has submitted that the relevant records, as indicated in the previous order for 24/8/2023, have not been received by him till date. He has prayed for 2 weeks' time to obtain the records. Because the list, the prayer made by Stephen Bharadwaj, Mr. Bharadwaj is allowed list the case on 26.
Your lordship will make it clear because this is
26.
because it is for final disposal, whole matter, madam.
Old matter, we have a list of
Yes, yes.
2006.
Yes.
Don't say it is old.
Item numbers 2 and 3.
Please, my lord. My lord, in this matter, we require some additional time to file our affidavit in opposition as well as affidavit in reply in the 2 connected petitions, my lord. Therefore, my lord, I will pray for 4 more weeks time, my lord.
My lord,
Which one?
my lord, there is only one difficulty, my lord. My lord, I have some urgency in the matter. My lord, so may I make one small request?
2023 matter.
Well, 2023, but it's urgent, my lord.
All cases are urgent.
I know, my lord.
Ah.
My lord, may I make one small request? My lord, he may be allowed to file his affidavit latest by 18th, my lord, so that the matter can be taken up on 26th, my lord. My lord, for 2 years, I have not been given electricity. On the basis of some
Yes,
unpaid
Mr. Borua, in which case you want to file affidavit,
In
counter
item
affidavit?
My lord, in item number 2, my lord.
item number.
Item number 2, you
Yes,
want to file counter affidavit.
Yes, my lord.
And in item number 3, you want to
File a
file
reply.
affidavit in reply.
Yes, my lord. And my
Okay.
lord, if I may submit, my lord, in this matter, they are already enjoying an interim protection from the honorable court, wherein temporary electricity connection was directed to be given upon payment of 75 lakhs. Now, if they have paid that amount, they can enjoy the electricity
But-
connection, my lord.
but-
Therefore, I do not see any
There was
express
some
urgency in this
difficulty
matter.
in that, therefore.
Are you having electricity connection, Ajay?
No, no, my lord, no, my lord.
My lord,
No,
they have
my
not
lord,
paid
I am
the amount.
arranging electricity by employing generators for which I am.
D. Goswami, learned counsel for the petitioner in 2. And for the respondent number 2 in item 3 is present. Mr. A. Borua, learned standing counsel APDCL, representing all the respondents
My lord, my
in
friend is for a-
item 2. All the respondents?
my lord, my friend is for an electricity ombudsman.
Except
My
1 to 4. 1 to 4. You appear for whom?
For the electricity ombudsman, my lord.
Okay. All right, so Mr. As they learned counsel for the electrical ombudsman or electricity ombudsman?
Electricity ombudsman.
For the electricity ombudsman are present. Mr. A. Borua, learned standing counsel representing the respondent number 1 to 4 in item 2 has prayed for and is granted 2 weeks time
My lord,
to file
4 weeks time, my lord.
My lord.
3 weeks time then. 3 weeks time
My lord, I'm obliged.
to file counter affidavit on behalf of the state respondents. Full stop. Mr. Borua, learned standing counsel, who is representing the petitioner in 3, has also paid for 3 weeks time to file affidavit in reply on behalf of the petitioner to the affidavit in opposition filed by the respondent number 2. Full stop. The prayers made by Mr. Borua and standing counsel, the above prayers made by Mr. Borua and standing counsel APDCL are allowed. Full stop. List the cases. Today one. 27, if affidavits are filed, then we'll fix
No,
it.
if it can be listed on the third Tuesday or a Thursday. because
Mr.
it is
Goswami, it is discretion of the court.
Yes. Deeply.
27. So that if the cases are, if affidavits are filed, we'll fix a date
My lord.
immediately within 2 days. But if the affidavits are not filed, then no purpose fixing it on a hearing date.
I'm
Thank you.
obliged.
Today it was fixed just for that,
Like,
to hear the matter,
yes, my lord.
but it could not proceed. What to do?
I'm obliged, my lord.
For hearing item number 9.
Yes, where is Mr. Borua? Hey. You are there? No. Hey, great whistle, 857, 2013. Talk material. Already, Adhar, university. CK is Borua all there.
I just.
Where is Mr. Borua who make a mention, who made a mention in the morning? এই কি কয় গ্ৰেচুইটি এখন লাগিব পেমেন্ট অফ গ্ৰেচুইটি এটা এই জাজমেন্টটা দিছিল যে এই জাজমেন্টটা দিছিল
Lordship, actually, what happened today in the morning, my brother, he telephoned me. And therefore, Lordship,
I made a mention, but I said that it is 2013.
no, what
matter.
happened, Lordship, I have left the file at home, Lordship. That's right. Lordship, basically, my stand is, Lordship.
No, that is recorded already.
Yes, yes,
Your submissions are recorded
yes, Lordship.
already.
I remember I studied yesterday.
And just because the private respondent was
Yes,
found
Lordship,
absent
yes.
also.
It is his case.
Basically, for that reason, primarily, the matter was adjourned.
Lordship, Lordship.
But yeah, otherwise, normally 2013 matter.
Basically, Lordship, in our affidavit, it was his defense, Lordship. Everything that is.
Okay, please take your seat. Let me have an idea. গরম হয়েছে Paragraph 12. 13. 12. 13. Paragraph 12 or 13. Well. At this stage, comma. It is found necessary to refer to the few provisions of the Payment of Gratuity Act 1972, comma, which are found of relevance for the purpose of adjudicating the issue involved herein. Full stop. As per section 2 within bracket small a, comma. No, nearly right. It is entirely provided in section 2A that quote up unquote appropriate government unquote means in relation to an establishment belonging to, comma, or under the control of, comma, the central government or having branches in more than one state, comma, the central government. Full stop. Quote. Completed year of service, unquote, comma, as per section 2 within bracket small b, comma, means continuous service for 1 year. Semicolon, and quote, continuous service, unquote, comma, as per section 2C, comma, means continuous service as defined in section 2A, 2 capital A. Full stop. Section 2 within bracket small e has provided for a definition of employee, quote unquote employee. An employee means, you have to put for you. Section within bracket small f has provided for the definition of quote employer unquote. And quote unquote employer means definition to be given. Section 2S has defined quote unquote wages and wages as under. Para. Section 3 of the Act, PF Act, has provided for a controlling authority. Full stop. Provided authority. And the appropriate government may, comma, by notification, comma, appoint any officer to be a controlling authority, comma, who shall be responsible for the administration of the PF Act, and different authorities may be appointed for different areas. Full stop. As section 4 of the PF Act has provided for payment of gratuity, comma, the provisions contained in section 4 have been quoted here and below for ready reference. Section 4 to go to review. Yeah. Section 7 of the PF Act has provided for the procedure for determination of the amount of gratuity. Full stop. As per subsection 7 within bracket 1, comma, a person who is eligible for payment of gratuity. লিখে দিব। Full stop. As soon as gratuity becomes payable, section 7 within bracket 2 has stipulated that the employer shall, comma, whether an application referred to in subsection 1 has been made or not, comma, determine the amount of gratuity and give notice in writing to the person to whom the gratuity is payable, and also to the controlling authority specifying the amount of gratuity so determined. Full stop. Section 7(3) has made it incumbent made it obligatory for the employer to arrange to pay the amount of gratuity within 30 days from the date it becomes payable to the person to whom the gratuity is payable. Full stop. As per subsection 4 of section 7, comma, if there is any dispute to the amount of gratuity payable to an employee under the Act or as to the admissibility of any claim of, comma, or in relation to, comma, an employee for payment of gratuity, comma, or as to the person entitled to receive the gratuity, comma, the employer shall deposit with the controlling authority such amount as he admits to be payable by him as gratuity. Full stop. Where there is a dispute with regard to any matter or matters specified matters, comma, the employer or employee or any other person raising the dispute may make an application to the controlling authority for deciding the dispute. Full stop. Subclause C of subsection 4 of section 7 has provided that absolutely by any video. Subsection 7 of section 7 has provided for a provision to appeal by providing that any person aggrieved by an order passed by the controlling authority deciding a dispute may, comma, within 60 days from the date of the receipt of the order, comma, prefer an appeal to the appropriate government or such other authority as may be prescribed by the appropriate government in their behalf. Full stop. The first provision to section 7 within bracket 7 has provided that the appropriate government or the appellate authority, comma, as the case may be, comma, may, comma, if it is satisfied that the appellant was prevented by sufficient cause for preferring the appeal within the said period of 60 days, comma, extend the said period by a further period of 60 days. First stop. The second provision to section 7 within bracket 7 has provided further that further that no appeal by an employer shall be admitted unless at the time of preferring the appeal, comma, the appellant either produces a certificate of the controlling authority to the effect that the appellant has deposited with him an amount equal to the amount of gratuity required to be deposited as decided by the controlling authority, or deposits with the appellate authority such amount. Full stop. As per section 7H, the appropriate government or the appellate authority, as the case may be, after giving the parties to the appeal a reasonable opportunity of being heard, confirm, modify, or reverse the decision of the controlling authority. Full stop. No appeal was preferred.
No appeal. Directly appeal petition.
Fair enough. The payment of gratuity within central rules 1972 have been framed in exercise of the powers conferred by subsection 1 of section 15 of the Payment of Gratuity Act 1972. Full stop. It is stated in rule, it is entirely stated in rule 10 of the PF rules, 1970 PF rules. That if an employer refuses to make payment of gratuity, a claimant employee can apply in form, quote unquote, N to the controlling authority for issuing a direction under subsection 4 of section 7. to decide the dispute. As the controlling authority has been empowered to direct the employer to pay an amount of gratuity can direct them to pay an amount of gratuity. If the claimant employee is found to be eligible to receive, found eligible to receive the gratuity, after due inquiry and after giving the parties to the dispute a reasonable opportunity being heard. এই যে ডিটেলসের হেৰি আছিল যে লেবাৰ ল ডিচিশ্যন কিবা আছিল যে লেবাৰ ল যে দুটা ডিচিশ্যন দিছিল in the case in hand, as has been found from above, as have been found from the discussion above, that, that. Good at number. The respondent number 2, as the claimant employee, submitted an application in form, quote unquote, capital N, before the controlling authority, that is the Assistant Labor Commissioner within bracket Central, Guwahati. Full stop. The Assistant Labor Commissioner Central Guwahati, acting as the controlling authority, had issued notices on receipt of the application, registered the same as application number, it has any PG, this. And issued notices to the parties in form, quote unquote, capital O, as required under Rule 11 of the Payment of Gratuity PF rules, calling upon the applicant as well as the employer to appear before him. Full stop. On receipt of the notice in form O, both the parties appeared before the controlling authority and made their submissions. Full stop. Represented their case, their cases. Full stop. It was after hearing the parties, the controlling authority had passed the imping order dated 12/11/2012, determining entirely that the respondent number 2, as an employee of the petitioner, is eligible to get gratuity and calculated the amount of gratuity as rupees 63,000 as payable by the petitioner. Full stop. A further sum of rupees 5,250 had been awarded towards interest full stop. Para. The petitioner. It is subtle. It is, it is. uh, as already noted above, comma, subsection 7 of section 7 of the PF Act has provided for a statutory remedy of appeal. Full stop. If an employer is aggrieved by the decision of the controlling authority deciding a dispute comma, it is open for the employer to prefer the statutory appeal within the stipulated period of time within the by depositing the amount required as per the second proviso to subsection 7 of section 7 of the PF Act. Full stop. It is settled position of law that a statutory appeal, an appeal, comma, is if provided by the governing statute, comma, is continuation of the original proceedings. And the appellate authority is well eligible, is entitled to reappreciate the evidence and materials placed before the controlling authority in order to confirm, modify or reverse the decision of the controlling authority. Full stop. Conspicuously, the petitioner herein has chosen not to avail the remedy of appeal provided by the statute. And instead, has chosen to assail the order stroke decision passed by the controlling authority passed by the controlling authority by preferring the instant writ petition. Full stop. Where it is well settled that a writ in the nature of certiorari can be issued can be issued in exercise of the extraordinary jurisdiction can only be issued can be issued in exercise of the extraordinary jurisdiction, but the jurisdiction is different from the appellate jurisdiction. Full stop. The jurisdiction extends only to cases where orders are passed by inferior courts or tribunals or authorities in excess of their jurisdiction or as a result of their refusal to exercise jurisdiction vested in them, or they act illegally or improperly in exercise of their jurisdiction, causing miscarriage of justice. Full stop. In regard to a finding of fact recorded by an inferior tribunal or authority, a writ of certiorari can be issued only if, in recording such a finding, the tribunal stroke authority has acted on evidence which is legally inadmissible, comma, or has refused to admit an admissible evidence, comma, or if the finding is not supported by any evidence at all, comma, because such cases, the error amounts to an error of law. Full stop. Your error of fact, comma, however grave, comma, cannot be corrected by a writ. Full stop. It has been held in so and so versus so and so 2008 for SSC 451 that whether it is a writ of certiorari or the exercise of supervisory jurisdiction, comma, none is available to correct mere errors of fact or of law unless the following requirements are satisfied. Colon, Roman 1. The error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law, comma, and 2, a grave injustice or gross failure of justice has occasioned thereby. Full stop. The High Court, in exercise of certiorari or supervisory jurisdiction, is not to convert itself into a court of appeal and indulge in reappreciation or evaluation of evidence or correct errors in drawing inferences or correct errors or mere formal or technical character. Full stop. Though the power of judicial review is available, yet its exercise is discretionary and the same is governed. Full stop. Para. A perusal. No. The controlling authority. A continuation or a continuation the appellate tachatal likhi debo coextensive likhi debo eta correct kore mai dibo. In his order stroke decision has arrived at a finding that the respondent number 2 claimant was employed with the petitioner organization for a considerable period of 13 years. And the said finding, according to the controlling authority, has been reached on the basis of records available and on merits. Full stop. The controlling authority has also returned a finding that at the time of retrenchment of the respondent number 2 claimant, employee could be respondent 2 employee, by the petitioner organizational petitioner, that is AFCCCG2. The respondent number 2 best employee was drawing monthly wages at rupees 8,400. And the petitioner as the employer did not contradict the particulars of the date of appointment, stroke intermittent employment, and last wages drawn by the respondent number 2 employee on the premise that the documents in relation to those matters were matters of proof on records. Full stop. The controlling authority had also observed that the petitioner as the employer had deliberately engaged the respondent number 2 employee on intermittent basis, which is short break in service in between 2 contract periods, with a view to deprive the respondent number 2 employee from the various benefits accrued from the social legislation, the beneficial legislations like the payment PF Act. Full stop. Publisher, the other paragraph 17 or 18, I'm saying. 17, 18, paragraph, get a mark for us. I don't think so. How about it is noticed that during the proceedings before the controlling authority, the petitioner that is the employer was represented beneficial, not social welfare legislation, no? By the Assistant General Manager of the AF so and so so and so. And the most of it is worthwhile to mention that sub-rule 3 of Rule 7 of the PF Rules 1972 makes it has 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 provided that a party appearing by an authorized representative shall be bound by the acts of the representative. Full stop. The controlling authority has also observed that the employer could not submit any document during the proceedings before him as regards the allegations about unsatisfactory performances on the part of the respondent number 2 employee, or as regards or any proof as regards stealing of any official documents by the respondent number 2 employee. Full stop. The controlling authority had further observed that taking of photocopies of the attendance register maintained by the AFC and so and so without their knowledge could not be construed as a major offense on the part of the respondent number 2 employee, as the same were as regards his proof of employment with the pedagoggy. It will be The contention made by the petitioner that as it maintains a branch office at Guwahati with 2 employees, comma, it would come under the provisions of section 1(3)(b) of the PE Act does not deserve acceptance. First off, as per section 1(3)(b), comma, the provisions of the Payment of Gratuity Act 1972 are applicable to every shop or establishment within the meaning of any law for the time being in force in relation to shops and establishments in a state, comma, in which 10 or more employees are employed, comma, or were employed, comma, on any day of the preceding 12 months. Full stop. On the other hand, comma, the provisions of the Payment of Gratuity Act 1972 are applicable, comma, as per section 1(3)(c), comma, to such other establishments or class of establishments, comma, in which 10 or more government employees are employed, comma, or were employed, comma, on any day of the preceding 12 months, comma, as the central government may, comma, by notification, comma, specify in their behalf. Full stop. When the provisions of the Agricultural and Processed Food Products Export Development Authority Act 1985 are looked at, comma, it is noticed that as per section 3, comma, it is the central government who is, comma, having regard to the objects of the act, and if it considers necessary or expedient so to do, comma, by notification in the official gazette, comma, is empowered to add to or, comma, as the case may be, comma, omit from, is empowered to amend the schedules to the act. Full stop. The chairman of the so-and-so, AF so-and-so, it is AF is to be appointed by the central government. And the chairman is the chief executive authority of the AFDA. And he exercises such powers and performs such duties as may be prescribed. Full stop. It is a central government. Who is the final authority to decide about the terms and conditions of services of the employees of ABDA, including remuneration, pension, leave, provident fund, medical benefits, etc. attached to the post held by an officer or an employee under the ABDA. Full stop. As per section 11 of the Act, comma, লিখে দিব, if the central government full stop. Under section 15, comma, the central government may, comma, after due appropriation made by the parliament by law in this behalf, comma, pay to the ABDA by way of grants or loans such sums of money as the central government may think fit for being utilized for the purposes of the Act. Full stop. As per section 20, comma, the ABDA shall carry out such directions as may be issued to it from time to time by the central government for the efficient administration of the Act. Full stop. As per section 31 of the so-and-so Act has provided that the provisions of the Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. Full stop. The controlling authority and in the order dated so-and-so has recorded that the ABDA does not have any other scheme of payment of gratuity or pensionary benefit more favorable than the benefits provided under the Payment of Gratuity Act 1972. Full stop. It is not in doubt that for for the author, for ABDA. For the petitioner, comma, that is the ABDA. The appropriate government as per section 2A. Within bracket Roman 1. Is a central government. Full stop. As per section 5. Which has provided the power to exempt, comma, I1. It will not list favorable, more favorable than not list. Five 1, liquid 5 2 liquid as per 5. From a reading of section 1(3)(b), comma, it does not emerge that a statutory body like the petitioner in the case in hand, which has a head office and who has the head office at Delhi and more branches in many states, comma, comes within the ambit of the ambit of subclause B of subsection 3 of section 1 of the PF Act. Full stop. From the statements and objects, statement of objects and regions of the Payment of Gratuity Act, comma, it is it was proposed that the appropriate government for administering the act in relation to establishments belonging to or under the control of the central government or a railway company, comma, or mine, comma, a major port and oil field, or in relation to establishments having departments or branches in more than one state, comma, would be the central government. Full stop. In the event a statutory body like the petitioner does not have any scheme. Of extending the benefit of gratuity. More favorable than the ones provided under the Payment of Gratuity Act. And it is not exempted under the purview of the Payment Gratuity Act by the Central Government in exercise of the power under Section 5 of the Payment of Gratuity Act, comma. This court is of the considered view that the Payment of Gratuity Act is applicable to the if the as the employer. Full stop. Having come under the ambit of subclause C of subsection 3 of section 1 of the Payment of Gratuity Act 1972. Full stop. In view of the discussions made above and before that. In view of the in view of the above obtaining fact situations, in view of the fact situation, discussed above, in view of the fact situation obtaining, as discussed above. In view of the fact situation obtaining the case in hand, as discussed above, this court does not find any good and sufficient reason to interfere the orders of decision made by the controlling authority in exercise of the powers under Section 7 of the Payment of Gratuity Act. Full stop. Consequently, the petition is found bereft of any merits and is liable to be dismissed. Full stop. It is accordingly dismissed. There shall, however, be no order as to cost. We waited for you.
Sorry, my lord, I have to.
There could be some correction, I think. Okay, এটা লিখি থব, এইটো এটা লিখি থব। You gave this decision, right? Uma Devi,
My lord,
basically Uma Devi,
yes, ma'am. Relying on Uma Devi.
Teja Singh.
Yes, ma'am.
এইটো নামটো লিখি দিব আমি চাই থৈ দিম হা এইটো 2020-19 SSC 811 This cannot be accepted because controlling authority has returned a finding that you were in employment for 13 years. And that is a finding of fact.
Yes, ma'am.
And we cannot disturb the finding of fact. It was the appellate authority who could have disturbed the finding of fact.
My lord, but
Finding of fact, you, for obvious reason, you have not preferred the appeal.
my lord,
You have preferred a writ petition. Trying to invoke the
but-
writ jurisdiction and for writ of certiorari. Scope is limited. You should have preferred an appeal that has coextensive power to either reverse, modify, or disturb the finding on fact. We are not, unless it is perverse. He has said, on the basis of records, he has reached the finding. So we cannot disturb.
my lord, the perversity was.
No perversity, he said, see the record. And you are not an organization, shop and establishment. That cannot be.
We are
You
not
are, you are an all India body,
undertaken for the month. We are a statutory body.
statutory body, you are not shops. An
Shop and
establishment under the Shops and Establishment Act. I forgot to write that. That 1(3)(b) is for shops and establishment who comes under the purview of Shops and Establishment Act in a particular state.
My lord, the establishment has a very
That is not defined,
connotation is there, my lord. Because
but I have seen their judgments.
he has 16 branches all over India. My lord, employee.
You have 16 branches.
My lord, the definition.
Okay, 16 branches,
My lord,
16 branches.
My lord.
CKS Boulevard. Submission legal. 16 branches.
if you have calculated that, right?
16 branches. Then how many employees?
Employee that has to, my lord, around 50. My lord, because the definition of employee, it is dependent upon the word establishment. My lord.
Establishment is not defined.
It's not in the act, my lord.
It is in the preamble, it is there. You come under that. Statement and objects, statements of objects. Anyway, we'll modify. If you look it over, our 2020-19 SSC, we'll deal with that.
Muscle, yes.
And 2004 to this court for acquisition of the following civil issued by whether the dismissal of 4 workers, namely Sri Bijoy Lasman, Sri Kali Budhwa, Sri Somra Etua, and Sri Sushil Budhwa by the management of Bogabani is justified. If not, what relief they are entitled. On getting the reference later, the case was registered by reference case number 14 of 2004 by this level. Notices were issued to the management of Bogabani and also to the representative of the ICMS, Margate branch, to appear before this court to file WS. The parties appeared before this court and filed in its WS to contest the case. The management, it is stated that the workmen, they assaulted the welfare officer Rajat Johar on 1/4/1999 at 11:30 AM. The delinquent employee, they assaulted without any reason. The welfare officer R. Johar asked the delinquent workman to work for lifting tea on the day
Slowly.
day of occurrence. However, they have showed reluctant attitude to work properly, who is entrusted to them. At the same time, when the labor welfare officer verified their performance at the site, it is found that they have performed duty negligently. The labor welfare officer, on asking them, they assaulted him and caused to him grievous harm. At that time, assistant manager was in charge of the garden and he informed the matter to manager in charge of the garden after the incident to Mr. P.K. Murali. At that time, Mr. Masood, manager, he was on leave. Accordingly, matter was informed to the manager. On his arrival, and the manager issued notices to the delinquent workmen to justify their act, and notices were issued to them at Annexure 4 to Annexure 18 to justify their act. However, the management failed to get proper reply from the delinquent employees. Then they initiated departmental proceeding and also they have been suspended. Thereafter, after thorough inquiry and also after collecting the evidence of both the sides, the inquiry officer filed inquiry report against them and dismissed letter are also sent to them dismissing the delinquent workmen by exhibit 21 to exhibit 32. It is pleaded that there is no ground to reinstatement of the workmen and also they entitle no benefit as paid for. It is also paid to dismiss the reference case. At the same time, the workman side also filed its WS to contest the case. It is pleaded that the case as initiated against them, it is a false and fabricated and the FIR was also lost against them, but they got acquittal as the case was false and fabricated. It is pleaded that they are innocent person unnecessarily harass them. It is also pleaded that the inquiry officer's report it was perverse. Therefore, it is paid to pass an award to reinstate them with full backwards. The management side examined MW1 Miss Arati Sharma, MW2 Lalit Sharma Bora, and MW3 Provin Kumar Murari.
This is before the labor court.
Management side also proved various documents to justify their action. At the same time, the workman side examined WW1 Sushri Budhwa, WW2 Birsa Daksam. As per the management, the workmen they are dismissed from service after holding inquiry, following the principles of natural justice. However, at the plea of the work, it's found that the allegation level against them of assaulting Roger Johar, it is false and fabricated. From the evidence of MW3 PK Murari, it is found that the workmen against whom charge sheet are filed for assaulting R. Johar at section 38 of South Side Division of the Garden. He also deposed that R. Johar informed him that the workmen Sushil, Kali, Somra, and Vijoy assaulted him, caused him grievous hurt, and at that time the workmen raised over at the garden at the time of assaulting R. Johar. Accordingly, notices were issued to the workmen for taking action to justify by them their act, and it is asked why necessary action shall not be taken against. MW1 Miss Arati Sharma, she had proved various documents and medical treatment of R. Johar, and she said that workmen assaulted R. Johar for asking them to perform duty sincerely. At the same time, MW1 Arati Sharma said that she informed the fact and filed the findings only that the workmen whose name already mentioned by the name. Arati Sharma is the inquiry officer. Sushil, Kali, Somra, and Vijoy, and she found them guilty for assaulting R. Johar. In this regard, she proved that inquiry report exhibit 14. She showed that she impartially investigated the case when it is handed over to her for inquiry. MW2 Lalit Chandra Bora said that at the time of incident on 1/4/1999, he was returned to perform his duty after lunch and he found Sushil, Kali, Somra, and Vijoy had assaulted R. Johar at the section 38 and he received them and tried to save welfare officer from them. Accordingly, he informed the matter to Assistant Manager MW3 Provin Kumar Murari on assault from R. Johar by the workman mentioned in his evidence. At the same time, workman witness Sushil Budhwa, he said that he is the workman of the garden and the management suspended him by Exhibit C, suspension order by order date 2/4/1999, and charge sheet is filed against him on 4/8/4/1999 by Exhibit D, and he also filed reply Exhibit E of the Sushil Budhwa. Accordingly, charge sheet is issued against other workmen also. In his cross-examination, it is also found that at the time of incident, PK Murari was in charge of the garden. At the same time, WW2 Birsa Daksam, he said that he does not know about the incident at the time of his service and no incident occurred during his tenure of service. WW1 Sushil Budhwa said that he heard of assaulting the welfare officer by the workmen. Then he came to the place of occurrence and saw the incident. However, he wants to say that he was not involved in the LS incident. At that time, there was 200 to 50 workers gathered there. From the evidence of MW3 Provin Kumar Murari and from the evidence of MW1 Miss Arati Sharma, it is found that MW1 who inquired the incident and filed findings against the delinquent employees. However, she does not see the occurrence. She is the inquiry officer. And MW3 PK Murari also did not see the occurrence. However, he has been informed by MW2 Lalit Chandra Bora that Sushil, Kali, Somra, and Vijoy assaulted R. Johar and also afterward they injured R. Johar. It is found that MW3 PK Murari also did not see the occurrence. In this regard, MW2 Lodit Chandra Bora, he said that he saw the incident and he is only the eyewitness of assaulting the injured Arjun. However, from the evidence of Sushil Budua WW1, I have found that about 200-250 workers gathered here at the place of occurrence at the time of incident. There was chaos and unruly situation prevailed at that time. It is also found that from Exhibit 14 that management witness number 4, Dr. N.R. Dev examined and treated R. Johar. However, as per him, R. Johar got serious injury. However, it is found that the management side does not examine Dr. N.R. Dev to prove the medical documents as is for this, but he was examined in the injury officer before the inquiry. It is also found that the management side does not examine the injured R. Johar, though he has been examined in the domestic inquiry. And he said in the domestic inquiry that Sombra, Ekura, Kali, and Piron Ratiram assaulted him, and the same persons assaulted him when he asked for becoming sincere in performing duty. However, it is submitted that the main witness, the injured R. Johar, has not been examined as he is the eyewitness as well as he is the victim of the incident. From the evidence of MWs and also from the WS, I have found that there was a gathering at the place of occurrence. So it becomes very difficult, I feel, to detect the persons among the crowd who involved the assaulting the assistant manager, Mr. R. Johar. MW3, Prabir Kumar Murai and MW1, Ms. Arati Sharma, they have failed to say the part played by the delinquent workmen at the time of the incident in details which is required to establish involvement of the delinquent employees with the alleged incident. Let's say in this regard, let's say posing for that moment, let's say Prabir Kumar Murari, he was informed, let's say he has deposed that say regarding the Ms. Arati Sharma, she is the inquiry officer. So she has inquired the matter as per the procedure followed by following all the procedures, and accordingly she has given her findings. So from the evidence of MW2, Lodit Chandra Bora, it is found that he saw the incident when he was returning from his lunch break. However, it will be very difficult to accept his evidence that at the crowd, how he identified the delinquent employees in their involvement. It is not a probable story to be accepted by me, though from the certificate of medical treatment, right, Exhibit 1, Exhibit 2, it is found that R. Johar has been examined by the Department of the Radiology of GNRC Guwahati and also took treatment at IOC Hospital initially after the incident. At the same time, it is also proved that Exhibit 3, Exhibit 4, Exhibit 5, and Exhibit 6 suspension letters of the workmen, Sushil, Kali, Sombra, and Vijay. Exhibit 3 suspension letters of Sushil Budua. At the same time, Exhibit 7 charge sheet, Exhibit 8, Exhibit 9, Exhibit 10 charge sheet are also proved. At the same time, Exhibit 11, Exhibit 12, Exhibit 13, Exhibit 14, Exhibit 15, Exhibit 16, Exhibit 17, and Exhibit 18 are also the reply on the charge sheet by the delinquent employees. Thereafter, inquiry was initiated and finding has gone against the delinquent employees, and afterwards they are terminated. At the same time, it is found that the workman side also proved medical report Exhibit A, Exhibit B CT scan report of R. Johar, Exhibit 6 suspension order, Exhibit D charge sheet, Exhibit E workman reply, Exhibit F notice of inquiry. From the above documents, I have found that inquiry is conducted by providing all opportunity to the delinquent workmen from Exhibit 1 to Exhibit 33. I have found that the management dismissed the workmen in question. So initially, the labor court has told that the domestic inquiry was conducted by providing all the opportunities. However, the matter of dismissal, it was challenged on non-application of the principle of natural justice. As a result of that, it is found that it is submitted there. It is submitted there, and it is held there. Principles of natural justice has not been followed in this. That's it. One hand, labor court has held that principle inquiry is conducted by providing all opportunity. Now, in terms of the basis on the submission of the workman, it is held that the principles of natural justice has not been followed in this case.
What is that?
In the earlier paragraph, from the above documents, I have found that the inquiry is conducted by providing all opportunity to the delinquent workmen from Exhibit 1 to Exhibit 33. I have found that the management dismissed the workmen in question. That means all opportunity was granted to the.
The matter of dismissal, it was challenged on non-application.
On the basis.
Result of that, it is found that I have not understood this
Yes,
meaning.
I have also not understood.
Mr. Bhagwat will explain.
Because on the basis of the submission made by the workers.
Sit, when your term comes, I do not understand this meaning
I also failed to.
in the same paragraph. However, by the word however, he has made.
However, the matter of dismissal, it was challenged on non-application, the principle of natural justice. As a result of that. It is
Of that, of that.
of that, it is found that it is submitted that, again, it is submitted that, that means the workman side has submitted, lordship. That, and it is held that, now it is held that the principles of natural justice has not been followed in this.
I have not understood anything.
Lordship,
This paragraph I have not understood.
on one hand, the learned labor court has held in our favor, lordship, in earlier paragraph.
Let us proceed.
Therefore, chance is to be provided to the management to prove the case by their evidence, and the chance is to be given to them. Also, it is submitted by the workman side. Now, chance may be given to the management, it is also submitted by the workman side. At the same time, the workman side also adduce their evidence. Considering the entire matter before me, the oral evidence and also the documentary evidence, I have found that the management side has failed to examine the injured RJO, and it is also found that no proper explanation is given for withholding him. That the management has worked with trying to trace out him to bring here for his examination on it. I find nothing. At the same time, no proper explanation is given withholding his evidence. At the same time, the doctor who attended RJO has not been examined, Dr. NRD. As a result of that, I have found that the actual injury caused by the RJO or his sustained injury due to the other reason, that possibility is also there. The management side has failed to substantiate so. The learned advocate for the workman, it is submitted that injury may be sustained by RJO for various reasons that can be assumed. It is also submitted that RJO sustained injury, it is suspected at the.
What is the meaning of this supratemporal? I don't know. I have seen it for the first time. What is the meaning? Huh? It meaning to be some? Supratemporal. Huh? Okay. Heavy.
It may be due to other reason, but the doctor commented that bone are normal. It is found that no abnormal focal of diffuse paranephral lesions seen in the suprantal compartment. Third and lateral ventricles are normal. Cerebral sulci aberrant pieces. There is no shift of the midline structure. No abnormality was seen in bone, and it was the impression no significant abnormality was seen in this study. It is certified by the 3 doctors of the Institute of Radiology and Medical School, Guwahati, Assam by Exhibit B and Exhibit 2 both sides group. As a result of that, it is submitted that the involvement of the delinquent employee it has not been established. It is also submitted that amongst the gathering, how MW2 Lodit Chandra Bora detected only the delinquent employee are involved. It is also unbelievable story. At the same time, MW2 Lodit Chandra Bora also failed to say the part played by the delinquent employee in the gathering by 9 persons only out of 250 workers. As a result of that, this evidence is also not believable at all. So he has to name all the 250 workers as part of the labor programs. As a result of that, it is submitted that the case has not been proved against the delinquent employees. However, the learned advocate for the management submitted the workmen in question Sushil, Kali, Sombra, and Bijoy. They are involved in the LS incident and they have exceeded the limit and tortured the management personnel, the welfare officer. There is no reason to think otherwise, but the court may hold them guilty. They are indulged, and if they are encouraged in such activity, it will be very difficult to run the industry. And as the welfare officer of the estate, his duty is the improvement of the condition of the workmen and also of the industry. Therefore, it is submitted that non-examination of the 100% RJO, there is nothing to disbelieve the management case and also the medical evidence laid by filing them the medical certificate. However, it is found that any certificate is issued by a medical officer if it is not proved by the same medical officer, such a certificate does not have any value. At the same time, injury is also not examined by the management side. Over and above, the evidence of MW2 LC Bora is also now at all acceptable due to situation under which we detected only the delinquent employees on their involvement out of huge gathering of workmen at section 38 of Bogapari List. Over and above, the management side why did not produce or no proper expensive even MW3 is revealed one worry. He also did not see the occurrence, but immediately heard about the incident after the plans. However, he came to know from MW2 Lodit Chandra Bora. Hereafter, from Arjohar as evidence of MW2 Lodit Chandra Bora itself is not acceptable and inadmissible in law for the reason mentioned above. I feel that when the evidence of the source thereof it is found free from biasness, in that case, the information of MW3 COVID body from MW2 Lodit Chandra Bora, the involvement of the workmen also of the incident, it would be, I feel, not at all acceptable. And it would not be a trustworthy evidence on the incident. As a result of that, I can not believe the evidence of MW3 PK Murari also. Under the circumstances, also it is found that criminal case also lost against the delinquent employees, and they are acquitted by session case number 7. As a result of that, I feel that management sides have failed to prove or to justify their action on dismissing Sushil, Kali, Somra, and Bijoy, and also as a result of that, the management is bound to reinstate them. and-
2 workmen expired. Is it required to substitute them? Because not required.
They have contested through union.
Huh?
They have contested through union.
Okay.
So accordingly,
Is it law that it is not required?
accordingly, I have awarded the case in favor of delinquent workmen and also against the management. And it is also directed to management side to reinstate them with full backward. Without giving any reason, without providing whether they are gainfully employed or not. And also in case of Somra proper monetary benefit is to be given to his heirs. Lordship,
1 minute.
in this case, Lordship,
1 minute. Let us see the judgment again. Award.
We started here.
Page 33, right?
Yes, ma'am. May I read also?
No, not really. Yes.
Okay, initially, learned level court has held that the inquiry was conducted by approving all the opposed and subsequently, on the basis of the submission, he has, learned level court has held that the principle of the natural justice has not been followed in this case. Lordship,
Principle of natural justice has not been followed where? Where?
before that,
Oh, I have not understood
yes,
the English written in page 37.
yes, sir.
37. Basically 38 first para. I have not understood it. I could not decipher what he has meant in this paragraph. I hope you can make me understand.
Lordship, but, whether,
Whether
the issue is that.
he says on the one hand, page 37. I have found that the inquiry is conducted by providing all opportunity to delinquent workmen from exhibit 1 to 33,
Yes,
right?
yes,
He has held. And he discussed whatever evidence this MW1, right?
yes, sir.
MW1, MW2, and MW3. Whatever they have stated before the labor code. Then he has discussed this workman Sushil Budhua, right?
Yes, sir.
Workman WW1 and WW2 Birsa Daskon. So 3 plus 2, 3 MWs and 2 WWs. Whatever they have stated before the labor code, he has discussed. What about the domestic inquiry?
Lordship, domestic inquiry, please 17, Lordship.
Right.
Against seven delinquent.
What he has done?
Domestic inquiry was conducted by MW1.
Yes,
Uh,
what he has
ROT
done,
ROT
what
Sabha.
he has done, the presiding officer, what he has done. Tell me,
Presenting that, yes, language problem is
no,
there.
language problem is there, what about the procedure?
Even procedure also, no, I don't think it has been followed. There is no question of presenting officer is not there.
That's all.
Inquiry officer is there only.
What,
No,
what?
the presenting officer was not
No,
there.
how this domestic inquiry report, there is a report,
Hello,
I have seen the LCR,
Lordship.
I have seen the LCR.
Ah.
First, they were suspended
Ah.
pending trial of
Therefore, sir,
initiation of domestic inquiry.
Lordship,
Then it was followed by SARSIT.
sir, see,
It was followed by
Sir,
written
sir.
replies
reply.
from the delinquent
Workmen side.
workmen.
Ah.
Then it was followed by a reply that your explanation was not
Not
satisfactory.
satisfactory.
Then let us appoint one inquiry officer.
Lordship,
Inquiry officer appointed.
Lordship.
Presenting officer was correct.
Then thereafter,
The
management
finding-
side examine witnesses.
Lordship,
Then thereafter, workman side examine witnesses.
Lordship,
And ultimately, it culminated into a domestic inquiry report.
Lordship. And that was.
Then thereafter,
Ah.
that inquiry report was forwarded to the workmen,
Lordship,
asking for their explanation. They submitted their reply.
Lordship.
Thereafter, the decision to dismiss the employee
Was taken.
was taken,
Lordship,
right?
Lordship,
So this is the procedure.
Lordship.
Now, what he has discussed, labor code. Tell me the law and the procedure.
Here are 3 witnesses mainly was this, out of that only
Oh,
one person.
When he gets the jurisdiction to discuss the evidence of witnesses, because I have also seen the written statement of the management before the labor code,
You have taken this.
paragraph 23,
Yes, sir. Exhibit
paragraph 23.
32.
The management further begs to state that they intend to rely on the domestic inquiry held by the management first.
Ah.
And if the learned court hold that the domestic inquiry is not in order and violative of the principles of natural justice, they intend to lead evidence to prove their case. Now, tell me, the law. Now tell me, address on the point of law.
I think Merely because the
He will not
language,
do.
language of the world.
No, language, no. This entire judgment,
There are
what
some
he discussed, what the presiding officer labor court discussed,
evidence of.
and
three
how he has discarded the domestic inquiry proceedings. Tell me which part of the order?
That has not
Both,
been,
tell me.
that has not been specified, that has been specifically specified.
Lordship, from Notebook Singh for initially Notebook Singh has prescribed the law regarding the delinquent, the management is required to be plead their case before their proceeding.
No, that right from Firestone.
Yes, sir. The subsequent law was settled in the Notebook Singh, and that was subsequent, thereafter the Shambhunath Goel has prescribed the timeline. It was initial stage.
Shambhunath has prescribed a timeline and thereafter Constitution bench has explained it,
Yes, sir. Now,
right?
now recent.
Constitution bench has explained it. Has the position been changed?
No, Lordship. The recent judgment I will find, Lordship. As with the.
What is the Constitution bench judgment
Lordship.
delivered by Santosh Hegde, Justice Santosh Hegde?
Ah,
Shambhunath was discussed.
Further, I like to argue that only that whether that it was, the punishment was disproportionate or not,
No.
whether the dismissal was necessary. Or there was other options should have been there.
No,
From 13, Lordship,
no, the law is different.
from 13, Lordship, this is.
Proportionality will come later on. Proportionality will come later on. Firstly, that management has taken a stand, clear stand, that we have done and conducted a domestic inquiry proceeding by following all the principles of natural justice. What I have said, all those documents were there, culminating into a domestic inquiry court. So law is clear, right from Constitution bench, also Shambhu and other things. For Constitution bench was judgment. So first he has to say why this domestic inquiry proceeding is bad.
In that
Right.
case, Lordship.
If he finds that domestic inquiry is bad for this region,
That has to be explained. This was recorded.
then only he gets the jurisdiction to decide on the evidence laid before him.
Lordship, recently.
That is not there.
Lordship, recently, learned single judge of this honorable court has.
Does the Honorable Court intends to send it back?
In paragraph 25, Lordship, it is clearly held.
No, day before yesterday, I have
By
passed an order. I'll go by my decision. Constitution bench judgment. Shambhunath Goel is 83-4 SSC 491,
yes, Lordship.
right? Constitution bench judgment 2001 5 SSC 433.
City, yes, Lordship.
Karnataka State Road Transport Corporation, Lakshmi Devamma. But the judgment. Judgment. But the judgment, Delhi Cloth and General Mills and Workmen of Firestone Tire still holds the field. It is just some subtle changes have been on the procedure, but it is still holding a field. I have seen it up to 2000.
Referring to 1972, Lordship.
No, after 72, that is 2001 Constitution bench judgment.
Same judgment.
That will prevail.
What more?
That will prevail.
If the 5 bench judgment is approving Firestone, then what more? Only Shambhunath Goel has been explained.
Explain
And that whether that was there or not, I have seen it.
Lordship, in our-
Paragraph 23.
our WS, Lordship, we have.
Paragraph 23 of your written statement before the labor court, it is clear
Yes.
that first you intend to rely on the domestic inquiry proceeding. Then if it is found that it is violative of the principle of natural justice, then they will rely on the evidence laid before the trial court.
And regarding the lordship back wages also honorable.
Backwards, this is the case for Iman,
Yes, that is, if the court feels it.
as
yes.
simple as that.
Yes, yes, because I also feel it that.
Because
judgment
he
is-
does not have the jurisdiction to decide
Yes.
on the evidence laid before him, before he decides about the
Only thing, lordship,
validity and propriety of the domestic inquiry proceeding.
as regards to the dead person, expert persons,
No, you are represented by this.
lordship, only my submission will
That
be.
does not, I have seen it.
Ah.
That does not make any change. It is not a case of substitution.
Lordship, I understand, but the persons long back they died. In a
That-
year-
no, really, when it is a case of remand, it's a case of remand, pure illegality.
That part is there, yes.
Because, see. One of the which has not changed, I can say principle number 3, paragraph 61 of Delhi Court. Right. When the management relies on the inquiry conducted by it and also simultaneously adduces evidence before the tribunal, without prejudice to its plea that the inquiry proceedings are proper. Now, next line. It is the duty of the tribunal in the first instance to consider whether the inquiry proceedings conducted by the management are valid and proper. If the tribunal is satisfied that the inquiry proceedings have been held properly and are valid, he has said, the question of considering the evidence adduced before it on merits no longer survives. It is only when the tribunal holds that the inquiry proceedings have not been properly held, then it derives jurisdiction to deal with the merits of the dispute. So, he first has to discard
Yes.
the domestic inquiry proceeding as not a proper one. Then only he can
He
go
can
on,
exercise jurisdiction.
discuss the evidence laid before him. So it is after that he can derive the jurisdiction. Otherwise, he cannot. So it is question of exercise of jurisdiction improperly. As simple as that.
Lordship.
Anything?
Lordship, that is a case of remand only.
Because there is inquiry proceeding, whole records are there. He has to discuss
Yes.
those evidence first on merit.
Only thing I do not know. if
And
those-
and that man, injured man, was this adduced evidence.
Yes, sir.
He had adduced evidence
Before the.
and
inquiry.
the doctor also.
Doctor,
Yeah,
I have seen it.
Yes, I'm sorry, sir. But they did not reduce the.
He has directed reinstatement on the basis that that man was not examined and that doctor was not examined. How can he do so?
Inquiry, during the inquiry, it was.
That is, but he could not have discussed it
Yes, sir.
without discarding the domestic inquiry first.
Lordship.
That is the law. Anything? Anything more?
No, Lordship. Remember. Remember what I did.
You have the Sambunath?
Yes.
Anyway, I have the constitutional judgment. Mr. Bhagwati, you represent respondent number one.
SMH.
Okay, the instant repetition under Article 226 of the Constitution of India is preferred by the management of Bogapani Tea Estates. To assail an award dated 7/11/2012 passed by the Planet Labor Court, Dibrugarh, in reference case number 14 of 2004. Full stop. By the award dated 7/11/2012, the Learned Labor Court, Dibrugarh. Union bracket, the Labor Court for South. Has held it. The management side had failed to prove or to justify their action of dismissing the 4 workmen. W2 capital VIJ 1 Sri Bijoy Lakshman, page 33 classes, right and number 2 Sri Kali Budhua, 3 Sri Somra Etowa, and 4 Sri Susil Budhua. Full stop. By holding so, the Learned Labor Court has observed that the management is bound to reinstate the 4 workmen, and in case full stop, or reinstate them, and in case, in view of the date of the workman named Somra Etua, since in the case of the workman named Somra Etua, reinstatement is not possible because of his date, sufficient compensation has to be given to the legal heirs of Somra Etua. Full stop. By deciding the reference in the aforementioned manner, the learned labor code has directed the management side to reinstate the workmen with full back wages and to disburse sufficient compensation in monetary terms to the legal heirs of the workmen, diseased workmen named Sombra Etoa. Right? Good stuff. In before the labor code, the four no, the workmen were represented by the
ACMS secretary,
Assam by the secretary,
Assam Shah Mazdoor Sangh,
Mazdoor Sangh,
Margarita Branch.
Margarita Branch, a trade union of tea garden workmen registered under the Trade Union Act 1926. Para. Just look at the facts I am dictating. It is not in dispute that the four persons, namely 1, 2, 3, 4. Visual Lasmon, where workmen were employed as workmen in the Bogapani tea estate. District Dibrugarh. Situate at district Dibrugarh.
It is
Tinsukia.
Tinsukia. Full stop. The genesis of the dispute was an incident allegedly occurred on 1/4/1999 within the premises of Bogapani Tea Estate. Full stop. The allegations level against the four workmen were inter alia to the effect that at about 11:30 a.m. on 1/4/1999, they had assaulted one Rajat Johar, Rajat, Johar, Johar, comma, and welfare officer of Bogapani Tea Estates. Full stop. The allegation was to the effect that when the welfare officer asked the workmen of the tea estate, including the 4 workmen herein, comma, to repluck the area properly, comma, an altercation ensued between them, and the welfare officer was assaulted, were allegedly assaulted. In at an area named section number 38 of South Side Division of the tea estate. Full stop. Alleging, no, full stop. After the alleged incident, comma, which occurred on 1/4/1999, comma, the 4 workmen were suspended on 2/4/1999 by suspension orders of even date. Full stop.
It's seated against 7 workmen. 7 workmen lordships are seated
Huh?
against 7 workmen charge was issued. Lordship, please.
Ultimately, we have to decide on the reference, right? Ultimately, reference.
Yes.
Reference is for against 4. Pending initiation of domestic inquiry and final orders to be passed thereon. Full stop. Thereafter, comma, charge sheets, comma, all dated 8/5/1999 were served upon the delinquent workmen asking them to submit their explanation as to why, asking them to submit their explanations comma, within the stipulated time period mentioned therein, comma, as to why disciplinary action should not be taken against them. Full stop. In reply to the search sheets, comma, all the 4 workmen submitted their replies on 17/5/1999. Full stop. After receipt of the replies from the workmen, 4 workmen, comma, the explanation, comma, the same was stated to be considered by the senior manager, Bogabani Tea Estate. Full stop. In the notice of inquiry, in a notice of, notices of inquiry were thereafter served. Notice of inquiry, comma, all dated 19/5/1999, comma, were thereafter served upon the 4 workmen, stating that the explanations furnished by them were found not satisfactory, and the management of Bogabani Tea Estate had decided to hold an inquiry into the charges level against them. Full stop. By the notices of inquiry, comma, the 4 workmen, along with other search-sheeted. No, here records are only 4. 4 workmen were directed to be present in the domestic inquiry proceedings with the observations that they would be given full opportunity to conduct their defense. Full stop. An inquiry officer was thereafter appointed. Full stop. In the inquiry, domestic inquiry proceedings held thereafter, comma, two. In the course of the domestic inquiry proceedings, comma, the management side examined how many? 5 witnesses as management witnesses, within bracket MWs, and they were MW1 Sri Pradeep Kumar Murari, comma, senior assistant manager, Bogabani Tea Estate. Roman 1. Roman 2. Sri Rajat Tohar. Rajat
Rajat Johar Lordship.
Tohar, comma, welfare officer. Bogapani Tea Estate.
MW3 Lolit Chandra Bora Lordship.
Huh?
MW3 Lolit Chandra Bora.
MW
It's 23.
3. MW3.
Yes, Lolit Chandra Bora, it's 23.
Lolit Chandra Bora. Comma Jamadar Babu. Bogapani Tea Estate. MW4, Dr. N.R. Dev, comma Senior Medical Officer, Bogapani Tea Estate.
MW5
And MW5, Mohesh
Jogdev.
Jogdev,
Yes.
comma Siddhar of Section 38, Bogapani Tea Estate. Full stop. MW 102. In bracket or legible. Examine and cross-examine. On 25/5/1999. MW2 bracket legible, examine and cross-examine on 25/5/1999. MW32 same. MW4 same. MW5 same. How many?
MW4 not examined. Lordship.
Huh?
Not cross examined with case 24.
1 minute.
4th paragraph. Lordship.
MW4, right?
Yes, Lordship. The witness was not cross examined by any of the workmen whose sides have duly noted. 4th paragraph. Lordship.
Examine on so and so will equal, huh? Actually, the management witness number 4, MW4, was not examined, cross-examined by the workman side. And how many from the WW?
Two.
Two. Their evidence are available or not available?
Evidence.
It is not actually.
Huh?
Workman only one. Lordship.
Domestic inquiry.
Domestic inquiry. Exhibit 32, Lordship. Domestic inquiry.
So after closure of the evidence from the management side, comma, the workmen side reduce their evidence through one Birsa Daskon as workman witness number one, WW number one. I think one witness.
Only one witness.
He's allowed. Only one witness.
After conclusion of the domestic inquiry proceedings, the inquiry officer submitted a domestic inquiry report dated 2/6/1999, wherein the inquiry officer recorded returned a finding that the four workmen were found guilty of the charges leveled against them. Full stop. It is pertinent to mention that the domestic inquiry proceedings were held against 7 number of workmen, including the 4 workmen mentioned herein. To stop the other 3 workmen against whom searches were also submitted were 1 Sri Kiran Amos, 2 Sri Samo Sunu, and Rotiram Kaur Singh. Full stop. In the inquiry report, the inquiry officer had held that the other 3 workmen were not found guilty of the charges brought against them by the management side. Full stop. Para. After submission of the inquiry report, the management side forwarded a copy of the inquiry report to each of the 4 workmen, providing them an opportunity to make representation regarding their case to the management before taking a final decision. On 5/6/1999. Full stop. The workmen were requested to submit their representations on or before 11/6/1999. Full stop. On receipt of the letter dated 5/6/1999, the 4 workmen submitted their representations before the management. Full stop. On 11/6 by on or before 11/6/1999. Full stop. After receipt of the representations from the four workmen, comma. The final decision in respect of the domestic inquiry proceedings were taken on 14/6/1999, and by communication of event at command, the management of Bogapani Tea Estate informed the four workmen that there were no extenuating ground or circumstances to deal with their cases leniently, and the management had decided to terminate their services. Full stop. The four workmen were informed that they were to be dismissed from service with effect from 15/6/1999. Full stop. They were full stop. Para. Being aggrieved by the said decision taken by the management of Bogapani Tea Estate to dismiss the services of the four workmen commander trade union, comma Messrs. Assam Sah Karmachari Sangha, comma Margherita Circle,
Yes.
through its secretary, comma raised an industrial dispute in respect of the matter of dismissal of the four workmen 1, 2, 3, 4. By government of Assam in the Labor and Welfare Department referred the dispute to the Labor Court by reference via the notification bearing number ZLR 164/2004/5 dated 1/9/2004. Full stop. The content of the notification reads as read as under. Double. Page 52. A to A. On receipt of the notification, Commander Learned Labor Court registered the same as reference case number 14 of 2004. Full stop. After registration of reference case number 14 of 2004, Commander Learned Labor Court by an order dated 13/9/2004, issued notices to the parties asking them to file their respective written statements along with all other documents on which they intended to rely. Full stop. On receipt of notices, the workmen's the management site filed its written statement on 23 on 2/5/2005. While the Walkman site filed its written statement to the trade union on
23/6 to
23/6/2005. Full stop. Para. From the management side, comma, it was contended in the written statement that the 4 workmen were dismissed from service for committing certain serious acts which amounted to gross misconduct as per the standing orders in force in the estate. Full stop. It was contended that the welfare of Rajat Johar, the welfare officer of the T estate was badly assaulted, was seriously assaulted on the alleged date of incident by the 4 workmen and as a result, Sri Johar was required hospitalization, required medical treatment and hospitalization. By stating that in the domestic inquiry proceedings, the workmen were given all the opportunities of defending their cases. In compliance of the principle of natural justice, the management side had contended that the dismissal, the domestic inquiry proceedings were fair and proper. Full stop. Since the charges, which were serious in nature, were proved against the 4 workmen in a domestic inquiry proceedings, the management side had contended that the decision to dismiss the 4 workmen by the management side required no interference. Full stop. On the other hand, the workman side in their written statement had contended that the charges were all false and concocted, and the workmen were victimized for their trade union activities. Full stop. The allegation of serious injuries sustained by Sri Johar were categorically denied. Post op. It was highlighted that in respect of the incident, first information report came to be lodged against the 4 workmen. But the the 4 workmen were acquitted from the charges leveled against them by the learned trial court. Full stop. It was contended that no proper domestic inquiry was held and the workmen were denied the opportunities, proper opportunity, adequate opportunities of hearing. Full stop. As such, there was no justification to impose the extreme punishment of dismissal. Full stop. Fair enough. After submissions of the written statements by both the sides, the learned labor court had proceeded to record the depositions of the witnesses from the management side on different dates. Full stop. From the management side, 3 witnesses, right? Namely MW1, ROT Pharma, within brackets, examine.
Inquiry officer,
Hmm?
case 29.
Examine on which dates? Cross-examine also? Examine and cross-examine on 31/8/2005. MW2. Lolit Chandra Bora. Examine on 19/3/2010 and MW3 Prabir Kumar Murari examined and cross-examined on 18/9/2010. Full stop. The learned labor court also recorded the depositions of from the depositions of how many? Two
Sunil Budhwa,
two
WW1,
witnesses from the workman side. That is
Sushil Budua,
one Roman 1.
Sushil Budua,
Sushil Budhwa. WW1 Sushil Budhwa.
another one,
Within bracket. Examine and cross-examine on 14/11/2005. And MWW2
Dixon.
Birsa Daskun.
Right.
Examine and cross-examine on 21/8/2010. Full stop. The learned labor court pronounced its award in reference case number 14 of 2004 on
7/11/2012.
7/11/2012. recording that the management side had failed to prove or to justify their actions in dismissing the 4 workmen. Full stop. It was held that no, sorry, the Learned Labor Court has proceeded to hold that had thereafter proceeded to direct reinstatement of the workmen, reinstatement of the 3 workmen and disbursement of sufficient compensation to the heirs of the released workmen Somra Etua, as mentioned here in above. Full stop. Para. Dissatisfied with the award passed by the Learned Labor Court on so and so in reference case number so and so, the management of Bogabani Tea Estate has preferred the instant repetition challenging the same. Full stop. Para. I have heard Mr. K. Kolita, Learned Counsel for the petitioner, and Mr. B. Bhagwati, Learned Counsel for the respondent number 1. Full stop. Mr. Kolita, Learned Counsel for the petition, has contended that the Learned Labor Court had proceeded wrongly and erroneously to decide the reference by discussing the evidence laid by both the sides before it, after the reference was made, without arriving at a definite finding about the validity and propriety of the domestic inquiry conducted against the 4 workmen, resulting in the orders of dismissal of their dismissal by the management. Full stop. Mr. Kolita has contended that the Learned Labor Court ought to have recorded its findings, definite finding on merits as regards about the domestic inquiry proceedings at first, and it is only after reaching a finding on merits as regards the legality and propriety of the domestic inquiry proceedings, the Learned Labor Court could have proceeded to discuss the evidence adduced before it. Depending on the finding reached about the validity and propriety of the domestic inquiry. Full stop. In response, Mr. Bhagwati, Learned Counsel, appearing for the respondent number 1, i.e. the workman side, has supported the award. Full stop. Mr. Bhagwati has submitted that the Learned Labor Court has appreciated the evidence of witnesses of both the sides, and it was after such appreciation the Learned Labor Court had observed that the management side was not justified in dismissing the 4 workmen from their services. Full stop. As the evidence of the witnesses did not inspire confidence of the learned labor court, comma, there is no ground for this court to for the report to disturb such findings. Full stop. Fair enough. I have given due consideration to the submissions of the learning council for the parties. And have also gone to the materials brought on record by the parties for their pleadings. I have also gone through the materials case records of reference case number so and so in original. Full stop. I have also gone through the records of the domestic inquiry proceedings conducted by the management side against the 4 workmen. Full stop. The sequence of events which preceded the impugned award have already been outlined here in above. Full stop. The alleged incident occurred in 38 number so South Division of Bogapani Tea Estate on 1/4 so had led to the issuance of the search sheets against 7 number of workmen, including the 4 workmen herein on so and so date. It's search date to review. On perusal of the case records, it is noticed that during the course of the domestic inquiry proceedings, the inquiry officer recorded depositions of five witnesses, MWs, from the management side, and to rebut the charges, the workman side adduced evidence of 1 witness, WW. Full stop. It was after recording the depositions of 5 management witnesses and 1 workman witnesses, the inquiry officer submitted the domestic inquiry report on so and so date. Full stop. On perusal of the contents of the domestic inquiry report, which is available in the case record and which has been exhibited as exhibit number
32.
32. Sure. Don't make me walk later on.
Domestic inquiry 32.
32. 32. In reference case number 14 of 2004, it is noticed that the inquiry officer had discussed the depositions of the witnesses from the management side as well as from the workman side. Full stop. It was after discussion of the depositions of all the witnesses, the inquiry officer recorded his findings that the 4 workmen were guilty of the charges level against them. And were found to be guilty of misconduct under the standing orders in force in the tea estate. And thereafter, the management side found them guilty of misconduct under the standing orders in force in the tea estate. To stop. At this stage, it is apologize to discuss the principles required to be followed in domestic inquiry proceedings by the management leading to the dismissal or discharge of a workman, MAN, stroke workman, and the procedure required to be followed by the Labor Code on receipt of a reference under Section 10 of the Industrial Disputes Act 1947, as amended, as laid down by the Honorable Supreme Court of India in a number of decisions. First of also para Delhi Cloth and General para 10. Para 10. Delhi Cloth and General Mills 72 1 SSC 595 para 60 1, huh? Para 11. Firestone tire. Para 12. Para 30. That was a constitution and judgmental. Shambhu. The constitution and judgmental was Shambhu, 2001. Mr. Kolda, what is this? This is regarding punishment.
Yes, sir.
This is regarding
Yes.
punishment. We are not on the punishment.
But, yes, there is
Shambhu Nath.
procedure also, Lordship,
2001. Ah. The decision in Delhi Cloth Mill Delhi Cloth Mill and Firestone came to be considered by a constitution bench of the Honorable Supreme Court of India in the case of Karnataka State Road Transport Corporation versus Lakshmi Devamma Union Bracket SMT and another, reported in 2001 5 SCC 433. To stop. The principle laid down in the by a 3 judges bench of the Honorable Supreme Court of India in Shambhunath Goel versus Bank of Baroda and others, reported in 1983 4 SSC 491 has also been considered by the Constitution Bench in Lakshmi Devarama Sutra. Full stop. Along with the decision in Alright. Full stop. Now, along with a decision in Cooper Engineering Limited versus PP Mundhe, reported in 1975 to SSS 661, where a conflicting observation was stated to have been made. Full stop. The Constitution, the majority view of the Constitution when judgment is under 16, 17, 18, 19. Full stop. When notices were, when after receipt of the reference, by the labor court, by the learned labor court, through notification bearing number so and so, dated so and so. Notices were issued by the learned labor court to the parties, provide order dated 13/9/2004, comma, the management side in its written statement, comma, filed on 2/5/2005, had taken a categorical stand that they intend to rely on a domestic inquiry held by the management first. And if after the learned court would come to a finding that the domestic inquiry was not in order and domestic inquiry proceedings were not in order and were violative of the principle of natural justice, comma, they would intend to lead evidence to prove their case. Full stop. Para. Itu পিছত দিব হা, পিছত দিব পেৰা আগত হ'ব, পেৰা 14। তাৰপিছত পেৰা 14 টো তাৰপিছত The right of the management to lead evidence before the labor court in justification of its decision under consideration by such court is not a statutory right. Full stop. The procedure has been laid down by the Honorable Supreme Court of India to avoid delay and multiplicity of proceedings in the disposal of disputes between the management and the workmen. Full stop. In the Constitution bench judgment in Lakshmi Devamma, the Honorable Supreme Court of India has stressed the history as to why such procedure is required to be followed in a case of dismissal or discharge of a workman. Full stop. Yeah. In the face of the such principles of law, in the face of such principles of law, a perusal of the award dated 7/11/2012 goes to show that it was submitted on behalf of the workman side that the domestic inquiry proceedings were not held by adhering to the principles of natural justice. Full stop. It was just after, it was by recording such plea from the workman side, the learned River Court proceeded to discuss and appreciate the evidence of the witnesses from the management side, 3 witnesses, MWs from the management side, laid before it after the reference. Full stop. The learned labor court had noted that the 3 management witnesses had observed that the 3 management witnesses who adduced their evidence before it, did not see the occurrence, did not see the alleged incident of assault. Full stop. It was further observed that the Dr. Enardale, who had examined and treated Johor is there? And was examined as MW4 in the course of domestic inquiry proceedings, was not examined before it, full stop. Similarly, the injured person, Rajat Johar, who was examined as MW 3 in the course of domestic inquiry
MW
proceeding,
MW2.
MW2, was also not examined before the learned labor court. Full stop. It was observed that observing the non-examination of these two witnesses as a failure on the part of the management side, with no proper explanation, the learned labor court had gone on to observe that involvement there, the management side had failed to establish the involvement of the delinquent workmen in the alleged incident of assault on Rajat Johar. Full stop. Submissions from the workman side as regards non-examination of the injured person as well as the treating doctor were accepted and the evidence of the three management witnesses were disbelieved. Full stop. Fair enough. The case in hand is one where depositions of 5 management witnesses and 1 workman witnesses were recorded by the inquiry officer during the course of the domestic inquiry proceedings, and those depositions were discussed in the domestic inquiry report dated 99. Full stop. Therefore, both the depositions of the management witnesses MWs and the workman witness WW and a domestic inquiry report dated so and so were available before the learned labor court. Full stop. The depositions of 3 management witnesses and 2 workman witnesses laid before it after the reference made by the government of Assam on so and so, were also available before the learned labor court. Full stop. In such obtaining fact situation, the learned labor court ought to have, in the first instance, proceeded to consider as to whether the domestic inquiry proceedings conducted by the management side were valid and proper or not. Full stop. If after such consideration the learned labor court had reached a satisfaction that such inquiry proceedings had been held properly and validly, the question of considering the evidence adduced before it on merits would not have survived, as it is settled that it is only when the learned labor court holds that the domestic inquiry proceedings conducted by the management side were not held properly and validly, it can derive jurisdiction to deal with the merits of the dispute before it by discussing the evidence adduced before it after the reference under section 10 of the Industrial Disputes Act 1947. First of para, eta para likhi dibo, it is settled, writ of such your right. Para. 16 going to go. Next, with the setting aside and set aside and passing of the impugn order.
Let's say one line may kindly be there. I'm representing the workman side. Therefore, workmen are equated in the criminal case. That line may be kindly, because after all, it is not safe for me.
One minute. Acquittal from criminal proceeding. That part. Where is the details of the criminal proceeding?
Criminal proceeding in the my
Which para? Where is? Somewhere I have seen.
in the my affidavit in opposition.
Okay, para. Acquittal in criminal proceeding. Yeah,
Benefit of doubt.
huh? Benefit
And
of doubt.
Session case number 34T 2000.
Where it is mentioned.
Case 14.
Page
14.
40,
1/4.
1/4
Lordship.
of the record.
No,
Lordship,
Lordship, my affidavit in opposition.
Started from page 9.
Internal page.
Earlier it was not separately done. Earlier.
Harinandan Ghosh, secretary.
Started from page 9.
Paragraph, tell me the paragraph.
Paragraph, it will be.
Paragraph.
At paragraph. Last
Paragraph 5 लिखिबो. Paragraph 5, affidavit in opposition. FIR session case, right?
Lordship, 34 of
Assistant session judge.
Lordship,
Assistant session judge.
Lordship.
Okay. Right, लिखिबो লাগিব. এটা line লিখিম. With the setting aside and passing of the impugn order dated so this court has no alternative but to remand the matter back again to the learned labor court Dibrugarh to decide the reference, that is reference case number so afresh in conformity with the principles required to be followed in a reference of such nature. It is accordingly remanded for the purpose of facilitating an expeditious consideration of the reference, both the contesting sides who are present before this court, are directed to appear before the learned labor court Dibrugarh on.
Sometime after puja.
Before puja or after?
After puja.
Before puja, you appear.
Already no
Before
problem.
Puja, you appear, then thereafter, he will not held the,
Oh, Lordship. Lordship,
fix a date of hearing
Lordship.
on 11/10.
Ah.
11/10/2023 by presenting a copy of this order to the learned council. Representing the two contesting sides have fairly submitted that for the purpose of appearances on 11/10/2023, the parties would not insist for issuance of notices by the learned labor court, Dibrugarh. First of it is expected that on such appearance of the parties before it on 11/10/2023, the learned labor court, Dibrugarh would proceed to decide the reference in an expeditious manner, preferably within a period of 3 months from the date of such appearance. It is made clear that any observations made in this order are made only for the purpose of testing the validity and legality of the award dated 9/11/2012, right?
7/11.
7/11. And none of such observations shall be construed to be observations on the merits of the claims of the respective parties. First of, the office is to send back the LCRs forthwith. এইটো লাগিব বাকি এইকেইটা লাগিব এইটা মাৰ্ক কৰা আছে ৰেজিষ্ট্ৰিটো চাই লব মাৰ্ক কৰা আছে সম্ভাৱনা টুৱেল এইকেইটা লাগিলে দি দিব অনন্ত মাতি দিব নহ'লে মাতি দিব
Here, Lordship, the apprehension is that the financial way is going to be open today. But as a copy of the served at 10:45, Lordship, we couldn't get the instruction, but we have instructed them not to open it today, and it is not being open, Lordship. Let it take it up tomorrow, Lordship.
Okay. Mr. H. Buragoi, learned counsel for the petition, and Mr. SMT Sisti, learned standing counsel, agricultural department. Are present. Mr. Sisti has submitted that though it is apprehended by the petitioner
Yes.
side that the price bid of the price bids are going to be open today, he has received instruction that the price bids are not going to be open today.
Yes.
As he has not been able to obtain further instructions, he has said he has paid for listing of the case tomorrow.
Yes.
Full stop. As the price bids are not going to be open today, as submitted by Mr. Sisti, let the case be listed tomorrow.
Oblige you. Oblige you.
I do put here you go. Video sign for you put here.
For hearing item number 4 to 8.
Mr. Roy, after going through the dictated part, I have seen that the state respondents' versions are not reflected.
No, that's what I was about to tell you.
I'll record. Then only I can make the final. order.
Right.
Please take your seats. Other councils, are you waiting for some other matters? I don't think the others can be taken up today. We'll continue with these 4 cases.
Well, in item number 4, WPC 1925 of 2009.
1925.
Lordship. Item number 4, part
Ah,
Well, the repetition is of, but it is very old,
very old.
Lordship.
It is 2009, but look at item number 5, that is of 2007.
Lordship. Well, in this case, I have sought for the up-to-date information. They have given me the instruction since Lordship is dictating the order, my lord, I'm pressing that. my lord.
I am not, I am what Mr. Nath,
Lordship,
I heard that day, Mr. Talukdar.
Lordship,
What I am doing, because all these are, see the volume of the
Lordship,
cases.
I have.
So till date, I have recorded what was pleaded in the writ petitions,
my lord,
right?
Lordship.
Today I am going to dictate. Hey, hearing multiple.
So in fact, in fact,
Today I
my
am
lord,
going to dictate what was the stand
of the respondent.
taken by the respondents in their affidavits.
My lord, one thing, my lord, I'd like to indicate, my lord.
Tell me, this is the position.
Lordship, lordship. My lord, in the writ petition, I find that the order by which the requisition order was issued by the ADC, it was cancelled by the DC. It was under challenge in the writ petition, in some of the writ petition. But my lord, the latest instruction I have received on 29th of August, this shows that in respect of 7 bigha land, acquisition process has been done and that 7 bigha has been acquired. Papers have been given to me.
Huh? Tell me,
Papers have
how? How?
Lordship.
Tell me how,
My lord,
acquired, how,
by issuing the section 4, section 6 notice. My lord.
take section 6 notification.
Yes,
When?
Section 4 only, my lord.
no, 4, 6 is also there, my lord.
6 is there.
Yes, yes.
There was an interim order, my lord.
Rumi, the award has been approved, my lord. Lordship, kindly see.
Money disbursed.
No, the first page, Lordship, may kindly see, because they said that because of an interim order passed in WPC number 2872 of 2013, they 2872 in the first page, my lord, they later returned to address to me, my lord. Last portion,
Not 28, you are the caller 7.
Lordship. The payment of land compensation has been kept on hold as Rabindranath Sharma and others filed writ petition before the Honorable High Court by WPC number 2872 of 2013. In this regard, pairwise comments have been sent. But I have some difficulty because all the records are old, those are all.
See,
all are not
Mr.
available
Nath,
with
we
the-
have been investing time
Correct.
on many dates.
Correct, my lord. So, Lordship.
There was no respect shown.
My lord,
It
I-
was of 2011,
Lordship,
all these notifications.
Lordship,
Those were not brought on record.
Lordship. My lord,
If you want to bring this on record, there are notifications, seems that there is a notification,
in fact,
declaration also, gazette notification
Gazette-
under,
Gazette notification
under 6,
under section 6, yes,
6.
award,
All these are required consideration,
correct,
but 12 years have gone by.
correct.
So at least I think this court needs some cost, imposition of such cost, heavy cost, to
Well,
bring this on record, because we cannot consider for in view of bringing this to the notice of the court
Lordship.
after elapse of 12 years. This notification is of 2011,
Yes, my lord.
right? All these are not brought on record.
No,
I have been going through it,
Lordship,
investing my time and effort,
my lord,
right,
lordship,
for many days.
lordship.
So it appears to be a act of disrespect to the court, not saying about mine as an individual. But 12 years, our notification was published in the Gazette, according to you, but not bringing it to the notice of the court.
My lord, I have
And
received it very recently.
Everybody will say
Lordship.
that cases are pending before the court for 17 years.
Correct.
Is it not?
But I have received this has come to my notice very recently, my lord.
Right.
My lord, in
So as an officer of the court,
lordship,
if these are relevant for the purpose of adjudication of the repetitions, those are required to be brought on record,
correct.
since these are Gazette notifications.
My lord.
Now, petitioner side have never said anything about this.
No.
And the State Council also have not brought this to the notice
Well,
at any earlier point of time.
Correct. No, that is why, my lord, before lordship started dictating the order today, my lord, I thought, my lord, it is because since the instructions.
I have to release it from Parter, then I will not go on doing it.
Now,
right.
now it has come. to
See my situation also.
I.
It is otherwise not not matters which pertain to bench for now.
My lord, I fully agree, my lord. I fully agree, my lord. It is, my lord.
Since I had gone through it,
Lordship.
so I thought that let me take the pain myself instead of sending it to my brother judges, right? So I thought that let me take the pain myself.
My lord.
Now, in the face of these notifications, it requires some kind of reconsideration, right?
But in fact,
So I'll not let the other court take. I
Well,
release
already-
it from Parter.
all the writ petitions have been reconstructed, my lord. These files are not available with us, and these have been brought to my notice very recently. My lord, I have written a letter to them because the old cases are pending for a long time, and my lord, where
I have
Our-
nothing to say.
our records are not available, entire records are not available in the
So
office.
you will need definitely 3-4 weeks time to bring this on record.
No, my lord, I
Ah.
humbly submit, my lord, since lordship is
But
dictating
I
the
am,
order.
I am not. going to
Dictating
do
the
it.
order.
I am not going to do it now. Since these are all notifications and all, right? Gazette notification, no. I'm
Lordship.
not. This appears to be some kind of, not on your part, on the part of the state,
Lordship.
some kind of disrespect to the
Award-
court.
But, lordship,
These are all 2011 notifications.
11 and 12 award has been approved in 12,
We are in 2023.
23, correct, my lord.
So not filing, not bringing these records, notifications on record
Lordship.
appears to be some kind of disrespect. I'm not
Lordship,
taking up this matter.
Lordship,
I'm
can you see-
expressing my mind clearly. Otherwise, these are not matters which pertain to Benchport now. Am I clear?
That's true. my lord. But the award has been approved in 2012, my lord, August 2012, my lord.
What kind of interim order? 23, it's not 2300.
Yes, sir. Eight is to Palana, 2872, Assembly, 2872, 2872.
2300, so.
Status quo, madam. Position restoration এর কথা তো নাহে আগে position restoration এর কথা নাহে, তো এই হয়ে গেছে No, the instruction to us, but the implement, A to copy, gadget not,
Land
gadget not.
acquisition.
It is gadget copy, ठीक है sir? It for seven बीघा, ठीक है sir? 7 बीघा 14 lakhs. Not the one.
Now, status quo order was passed on 9/4/2010. That status quo as regards the land in question shall be maintained. If that is so, then how could you publish the declaration in 2011? Status quo order on 9/4/2010 in WBC 2300. Not in what you said. Right? The 2013. no. Please note 9/4/2010 in WBC 2300/2010. Right? And in WBC 2872, in the order dated 22/7/2013, it was reiterated that interim order passed in WBC 2300/2010 shall continue.
Continue.
So, except 2300/2010,
Gotcha.
I don't think there are interim orders in any other petitions. And as it appears from this, that you made the declaration on maybe in 2011,
11,
right?
correct.
So whether this will sustain or not, that those are another issue, right?
Correct.
And because if the status quo is there, you could not have, as regards the land.
Gotcha.
So as regards the land means, which includes 7 biga whatever.
7 बीघा 14 lakhs.
Actually, it is 9 biga, somewhere 2 bigas gone missing.
No, but total 59 बीघा, 52 बीघा has already been done, acquisition has been done, it is
That is
complete.
what, 52 biga.
Gotcha.
Among those 52 biga, it appears 2 bigas of the petitioner's land were included. Right? Mr. Das? And this 7 biga 14 lesa, they have a different story altogether. One Makhan Lal Chakraborty and all were something, all. There is a different turn altogether.
Correct.
Right? But initially, 9 bighas, 3 kathas of the petitioner's land were requisitioned in 1986. In the course of all this, in 2004, in and around 2004, these 7 bighas, 14 lesas were shown to be de-requisitioned by an order of Makhan Lal Chakraborty. Then thereafter, all these incidents, there were other notifications also under section 4. Right?
Correct.
And other orders by the deputy commissioner that order of Makhan Lal Chakraborty is
Cancel.
invalid, cancel, something like that. But in the process, 2 bighas and plus 2 kathas of petitioner's land were among those 52 bighas, right?
Sale permission.
And
sale-
since no assistance apparently as regards facts, so I had taken the trouble to dictate partly so that,
Correct.
but now it seems everything has gone west.
Malad, I'm very sorry, Malad, for that, Malad.
No, it is not a.
Logic.
I am not attributing it to you, Mr. Nath.
Malad, what
I am attributing it to the state.
logic.
Don't take it that I am attributing this to you.
Malad, in fact,
It is a case of the court and the state, not
Correct.
Mr. Nath
correct.
or not Mr. Roy.
Gotcha.
Don't take it.
Logic.
individually.
I do agree. I do agree, Malord. But I, considering the long pendency of the repetitions, I sought for the up-to-date position from them, that in that case, Malord, it has come. And Malord, these are relevant, Malord, that is why at least I have to
Yes,
place it.
these are very, very
I
relevant.
have to place it, Malord, because they have issued the notification, Malord. Under what circumstances, of course, Malord, that Lordship will definitely see, Malord. But these are relevant. These are relevant. I have seen, Malord, they have prayed that their land 7 bigha 14 lesser should be rested. That is their prayer in the writ petition, Malord. Exploration to within one acquisition
Mr. Roy, it is difficult now for the court.
Lordship has, my lord.
See, I have seen two notifications. I have seen two notifications now. Both dated 6th August 2011. And first notification, it was under section 4,
That I.
whereby, no, that these are not there in the record. That is why I'm,
There.
please wait for it. It is not there. By the first notification, 52 bighas, 8 lessers were sought to be acquired. That is not there, Mr.
52 bigger.
Yes,
Or they will be earlier.
by the second notification, 7 bighas, 14 lessers. Both are of same date, 6th August. Two notifications under section 4.
Second.
Right. So those were not in the record.
Second is there.
Second is there,
First
but
is.
first was not in record. Then it was followed by
That is not there.
6 notification, 6 declaration. Right, that is of dated 14/11/2011,
That is in respect of what land, my lord?
52 bighas.
Oh.
52 and 7.
Plus composition were calculated. Also, maybe regarding 7 bighas, we don't know,
7 bigha is also there, Malord.
also there.
Yes, sir.
So, see, so in respect of entire 49 bighas,
50.
comprised of 52 bighas plus 7 bighas, there were notifications, 2 notifications under section 4, and there are 2 declarations under section 6 in 2011. Thereafter, award was approved, whatever. So it will take a different turn.
Obviously.
Anyway, this going court is not inclined, because it is otherwise, these cases are not pertaining to bench court. Just I thought that let me take the pain, since I have taken the pain, when the segregation notification was not there, so I continue to do these cases. Now, I don't think I'll not find any pleasure to continue. So let me record the facts and release it from Partha, allowing them to bring on record all these notifications.
That's
What more I can say? Pure wastage of judicial time,
Lordship,
not my time,
on
not
several,
my time,
Correct.
Obviously,
Court's time. The same time.
court's time.
This, my lord, they could have filed an affidavit in the case. They have not.
I don't know, Mr. Nath, what is the prayer of Mr. Nath now?
Malord, these records are available now with us, Malord. I have placed a copy, Malord. Court can take notice of this, Malord.
No, these are matters which requires
Correct.
that those should be brought on record so that they can respond,
That's right.
right? It is their lands. It is their lands. And they are seeking relief in the form of money or restitution of land. And they have been fighting it since 17 years.
They are challenging the requisition.
Whatever, they are pursuing the matter for 17 years. I don't see justification from your side that a petitioner has to run from pillar to post for 17 years. এক নম্বর যত order pass করেছিল এগুলো। And no, I will not continue with this. I cannot. This is otherwise not matters which pertain to bench 4. These are not matters otherwise of bench 4. These are bench 3. 5, bench 5, I'm sorry. But I continued. I dictated about 40 pages.
Correct.
I don't like,
Correct.
I don't like the approach.
But
I had Mr. Isdas Lanet, counsel for the petitioners in WPC number 1925, 2009, PK Roy Lanet, senior counsel, assisted by Mr. S.K. Chakraborty Lanet, counsel for the petitioner in all the other 4 petitions, right?
Yes, ma'am.
You present 4. Mr. Dinath Lanet, senior government advocate, Assam,
Affidavit of deeding.
has submitted that he has received instructions in respect of the parcel of land stated to have belonged to the petitioner and which were requisitioned by the order dated 22/10/1986. Full stop. He has submitted that parcels of land, measuring 52 bighas, 1 katha, 8 lessas on one hand, and 7 bighas, 14 lessas on the other hand, were sought to be acquired by issuance of 2 notifications, both dated 6/8/2011, under Section 4 of the Land Acquisition Act 1894, within brackets since repealed. Full stop. The notification dated 6/8/2011 pertaining to the parcel of land measuring 52 bighas, 1 katha, 8 lessas under Section 4 of the Land Acquisition Act 1894, since repealed, was followed by a declaration under Section 6 dated 14/11/2011, and the same was published in the Official Gazette on 16/11/2011. Full stop. In a similar manner, a declaration under Section 6 of the Land Acquisition Act 1894, since repealed, was published on 14/11/2011 in the official gazette. In respect of the other parcel of land measuring 7 bighas, 14 lessons. Question. It is further submitted by him that award in respect of both the parcels of land which were acquired through the acquisition proceedings in LA case number 3/1986, have since been approved. Full stop. He has submitted that the amounts of compensation for amounting to rupees 10 crore 2,20,760 for a parcel of land measuring 52 bighas and and
52 bigger, 1 kata, 8 lesser.
and rupees one crore 36,87,380 for the parcel of land measuring 7 bighas could not be disbursed due to an interim order operating in this batch of repetition.
Well, 50 in respect of 52 bigger, it is already released to the particulars.
Okay.
7 bigger.
Or were approved insofar as the 52 bighas so and so, the compensation amounts have already been released. Full stop. It is the compensation amount in respect of the other parcel of land measuring 7 bighas so and so 14 lessons. The same could not be released to the claimants stroke persons interested due to an interim order operating in this case. Mr. Roy, you want to accept this 1 crore 36?
No,
No.
I'll get
you-
get back my land.
Huh?
I'll get back my land. I'll put a challenge to this. I'll get back my land.
Okay, so stop. Mr. Nath has thus submitted that as he has received those instructions very recently, he wants the same to bring on records by way of an additional affidavit. Full stop. Where? This batch of writ petitions five writ petitions are of the are the subject matter of challenge in these writ petitions is the is a parcel of land measuring 10 bighas, 1 katha, sorry, measuring 9 bighas, 3 kathas, covered by dag number 146 and patta number 14, situated at village Gorpandu Kumarpara, Moja Jalukbari, and full stop. The matter of requisition or alleged disposition of an area measuring 7 bighas, 14 lessas, which is a part of 9B3K, is also an issue in this rate petition, in this batch of rate petitions. The rate petitions were for the first of two of these rate petitions pertain to the year 2007. Para. Meaning thereby, that the two rate petitions are pending since for a period of 16 years. This could, those the rate petitions were heard on earlier dates, and the court was in the process of dictating the order, in view of the above submission made by Mr. Das that certain relevant notifications are not brought on record, the court is of the view that from the matter, the repetitions be heard at a later date. The last of the writ petition was filed in the year 2013. Most of the on a cursory perusal. No, so sorry. The notifications under section 4 and the declaration of section 6 of the Land Acquisition Act 1894, since repeals, which have been referred to by Mr. Nath, Senior Additional Government Advocate, are of the year 2011. Those are the notifications that that the act of not being the notifications pertaining to a year 2011 are primarily suggestive of an act on the part of the state respondents which cannot be said to be in the interest of justice. So submit that as it may. Comma. Let the cases be listed after 4 weeks in order to bring the relevant instructions, including notifications, etc., received by Mr. Nath, senior government advocate, by way of an additional affidavit. Full stop. The full stop. By furnishing a copy of the same to the learned counsel for the petitioner's side. Full stop. List the matter. The writ petitions are released from part heard. The cases be listed before the appropriate bench.
But one small addition, but there are two LA cases. One LA case is 3/86 in respect of 52 Bihar. Other is LA case number 3/86 part A.
Okay,
Two cases.
party. Good, I can tell you.
Lordship.
Take your.
Lordship.
An exercise in futility.
That's right.
Take these written submissions also in the record.
Lordship.
That is of no use now.
Sorry,
I am more ready to.
Lordship, will-
Dictation for 2 ladies.
Lordship. It's a very sorry state of affairs, Lordship. Otherwise, in existence of these documents, proceeding in the other direction is also not.
Now it has to be reheard.
Correct.
So I was not made aware of
Correct.
existence of these notifications.
Absolutely, absolutely.
So we have proceeded
In a
in
different.
a different line altogether because the state councils were hard.
Correct.
And I have dictated the order, whatever, these are facts which are to be extracted.
Correct.
Lordship has given it to us from time to time.
And from time to time, whatever I have dictated in the presence of all the councils,
Lordship.
so that no facts are wrongly dictated
Wrong.
and reproduced,
Correct.
right? Thereafter, I have made them to see whether any corrections are required to be made on the facts. Let the law part will be dictated later on.
Correct.
So it proceeded for last 2-3 months like that.
Correct.
In the meantime,
In-
that notification segregating the matters between bench 4 and bench 5
It has come.
came into being. So I thought that since I have taken the pains, let me take the pains
Lordship.
for some further period. Right?
Correct.
So that is why I kept it as a pattern. So
Correct.
This ought to have come on the very first day.
In the,
what to
during,
do?
during the course of hearing, actually, the matters have come to my notice. Earlier, I was not.
Right. You have taken the right steps. I am not saying that you are not taking the proper, you have taken the proper steps,
Correct.
but it has come belatedly and quite
Too
belatedly,
late. It's too late.
quite belatedly after 12 years.
Too late.
Right. This is the obstruction to the course of administration of justice.
Lordship.
I think that is what. I am not worried about my wastage of time. I am worried about the judicial time.
Lordship.
That's all. I have nothing to say. Only thing that I could have invested the time in a better manner. I think I have lost at least 4 or 5 main days. Man
Lordship.
hours.
Correct.
Anyway,
Correct.
Item number
maybe
13.
we are not taking up other matters. That's all. Anything. I have asked them to go because I thought that this will take time up to 4:30 and beyond 4:30.
But I'm very sorry for
No,
this.
no,
Lordship. No,
I have
What-
nothing against you.
what has happened, because these things are not very inspiring.
I have nothing against you, Mr.
But-
Nath. Don't take
I-
it personally.
I fully, Okay.
I am about the institutional
Correct.
time
Correct, Lord. These things, these
and
things are not
course of
ins-
administration of justice, nothing else.
not inspiring. Lord.
Not my wastage of time,
Lordship.
personally.
Lordship.
But at least I think as a head of the office, you should take proper steps.
My lord, definitely, definitely, my lord, definitely.
These are not in good.
Lordship.
Mr. Roy has spent time, Mr. Das has spent time, Mr. Talukdar, Mr. Borua, all these, they have spent time.
Correct. In
At
fact,
the end, it is an exercise in futility.